Hello and welcome to the Sidebar presented by True Crime News, taking you inside the courtrooms of high-profile and notorious cases from across the country. I'm your host, Joshua Ritter. I'm a criminal defense lawyer based in Los Angeles and previously an LA County prosecutor for nearly a decade. You can find me on all social media at Joshua Ritter ESQ or at joshuaritter.com. We're recording this on Friday, June 28th, 2024. In this week's episode, a judge finds himself on the opposite side of the bench as he's ordered to stand trial for the shooting death of his wife. Plus, a misstep by the prosecution of an OnlyFans model charged with murder as a judge rules to exclude a key piece of evidence. But first, deliberations continue into their fourth day in the case of Karen Reed as jurors decide whether the woman is responsible for the death of a police officer or the victim of a massive cover-up. I'm flying solo this week, folks, so I know we have a lot to cover. I've been paying attention to these cases. Bear with me. Let's jump right in. First, we move to Denham, Massachusetts, where the fate of a woman charged with the death of her police officer boyfriend hangs in the balance as jurors deliberate the evidence and the defense claims of a massive cover-up. Karen Reed is charged with second-degree murder after prosecutors say she hit her romantic partner, John O'Keefe, with a car and left the man to die in the snow. Reed's defense contends that O'Keefe was actually killed in the home of another officer before his body was dragged to its eventual resting place. In closing arguments, Reed's defense stuck to the rhetoric they maintained throughout the proceedings, with lead defense attorney Alan Jackson stating, quote, "There was a cover-up in this case, plain and simple," alleging that O'Keefe was likely killed in an altercation and bitten by a German Shepherd before his body was staged. The defense presented multiple expert witnesses to close their case, all with the intent of casting doubt on the shards of taillight from Reed's SUV that were allegedly found at the scene. Prosecutors, meanwhile, started their arguments with Reed's comments to first responders after the discovery of O'Keefe's corpse, alleging the woman's refrain of "I hit him, I hit him, I hit him" was an admission of her guilt. Prosecutor Adam Lally conceded that the conduct of John Proctor, the lead investigator in the case, was reprehensible, with the trooper sending multiple derogatory text messages about Reed. However, he asserted that those actions didn't undercut the entirety of the investigation. As we record this on June 28th, the jury has entered day 4 of deliberations with no verdict yet in sight. However, we will update you as we have a verdict in this highly publicized case. And in fact, before we sat down to record, I heard that there was, in fact, another question from the jurors. So we don't know what that is at the time of this recording, but it may hopefully shed some light on where the jurors are. But the big question that everybody has is, because it's been taking so long, quote unquote, and I put that in quotes because we're talking about a trial that lasted 8 to 9 weeks. There were 70 plus witnesses called in this, experts, DNA evidence, accident reconstruction evidence. This was a very dense and long trial. And so the idea that they've been deliberating for 4 days now is not outrageous to me. I think that is still within the realm of typical, and nobody should be hitting the panic button. We have not heard, unless that's what the question is this morning, that there's any question about what do they do if they're hung, how, some sort of question about what is reasonable doubt, something that would, lead attorneys to start pulling their hair out as far as wondering whether or not these jurors are able to reach a decision or if in fact they're at an impasse. In fact, today's Friday that we're recording this. Juries, for some reason, love Friday verdicts. It's also a Friday before a holiday week. I imagine if they have reached a decision or are close to reaching a decision, they were probably feeling their own internal pressure to get that done and wrapped up by today. So that is something I would expect. Again, one of the favorite pastimes of trial attorneys is trying to read the tea leaves of every little noise that comes out of a deliberating jury's room. Whether that be their questions or even their silence, trying to figure out what all that means. Are they hung? Is it a quick verdict means it's guilty, or does a long verdict means it's not guilty? I mean, you could go back and forth for hours and you never seem to be right. And so I would just say these attorneys are probably doing their best to just remain calm and anticipate that, they did their best job. And I think both sides actually did a very admirable job in this with what they had to work with is kind of the caveat I'll leave it at. Let's talk a little bit about the closing arguments. The defense, and this was interesting. You don't see this, but every jurisdiction's a little different. But in Massachusetts, the defense goes first in their closing arguments, and then the prosecution goes last, and that's it. I'm used to, here in California where I practice, that actually the prosecution goes first in what's called their opening closing argument. Then the defense goes, and then the prosecution is allowed to present a rebuttal because they have the burden of proof. And to some extent, that gives the defense a little bit of an advantage, not an advantage, but more advantage than I think they had here in Massachusetts, in that the defense is allowed to hear what the prosecution is going to say and respond to that. They didn't have that opportunity here. Alan Jackson gave closing arguments, and he's essentially operating in the dark as to what Adam Lally was going to say in his closing. Now, in a case like this, for as long as it's going on, I don't think anybody was surprised by the arguments being made by either side. So he anticipated likely what they were going to be, but he didn't have a way to respond to anything he specifically said in his closing. The other thing that was interesting is they were limited to an hour. An hour for 8 weeks of trial is a very short timeline to try to summarize everything. So I know that a lot of people who've been watching this trial may have had some critique for why didn't they mention this? Why didn't they get into that? One thing I noticed is that neither of them got into actually the elements of the crime. But I think that's more of a function of a 1 hour time limit than anything else. They had to make choices, and they had to trim the fat as much as possible to get the important information out there for the jurors in their summation. But Alan's summation began with the words, "Look the other way." I thought that was powerful. It presents a theme, and that theme, if you break it down and really think about it, is a great theme for the defense, especially in this case, because the idea was the prosecution has been trying to infantilize the jurors every step of the way by presenting evidence and then asking them to ignore other evidence. Look the other way about things that should be troubling to you. That's not important. It's a way of almost treating the jurors as if they're children or if they're stupid. And his argument was to empower the jurors by saying almost they have this higher calling, that it's their responsibility to stand between this corrupt police system and justice. And however you feel about whether or not the defense proved their case, that's still a powerful argument. For the prosecution, Adam Lally has been criticized a lot for how he is as an attorney, and I don't think he deserves much of that. He's not dynamic, especially compared to someone, a seasoned trial lawyer like Alan Jackson. But it's just not in him. I think it is part of his personality either. He's a much more matter-of-fact person, which is kind of what you want out of a prosecutor anyways. But because of that, I think he actually did a very good job given what I think most folks may have expected from him. And he started out with the words, "I hit him, I hit him, I hit him." And this is a refrain, if you've been following this case at all, that you're very familiar with, because these are apparently the first words to have come out of the defendant's mouth when they discovered his body. Or maybe not the first words, but soon thereafter. And when first responders are coming to the scene, that is how she's talking to people when they're asking what had happened to him. And that's a very powerful part of the prosecution case. If you believe this is a cover-up and the evidence was planted and everybody's lying and everybody's trying to frame Karen Read, you still got a problem with those words, "I hit him, I hit him, I hit him." And I know that the way the defense addressed that is try to say, well, that was "I hit him?" ? Or did I hit him? And they did about as much with that as they could. But still, you had witnesses saying those words came out of her mouth. Powerful stuff from the prosecution and difficult to deal with if you believe the conspiracy theory of this case. I think my final thoughts on all of this is we talk about a lot of really fascinating cases on this channel and in this podcast, but it's rare, I think, to see a case that didn't involve a celebrity or a sports figure really catch fire like this. And I keep wondering about why that is. You know, we saw, we see cases involving celebrities all the time. We see cases with real intrigue. Corey Richins is a case that comes to mind where you have a woman who allegedly poisoned her husband and then wrote a grief book about it. And you can understand why that might involve intrigue. This case is about somebody allegedly running someone else over with their vehicle. And I realize that you have a female defendant. They may cause some intrigue, but really you're talking about a suburban community outside of Boston. Neither one of them are celebrities. I think it just demonstrates more than anything how we're really fascinated just by mysteries. And when we just quite don't know what happened and there's enough of a question about that for both sides of the issue to kind of run to their corners when they hear a new piece of information, and there's a spin factory on either side being able to explain any piece of evidence or whether or not you should pay attention to it, whether or not you should ignore it. But in this case, it really had a life of its own. And it's fascinating and it's continuing. This is exciting. We just found out as I'm literally sitting here doing this recording that in fact, that question from the jurors was an indication that they're deadlocked. And so I know that's sending the entire Karen Reed Twittersphere into a tailspin at this point. And they have been deliberating for a while. And what we have learned is that the judge did instruct them to go ahead and take lunch, then go back and deliberate some more. Again, not entirely out of the ordinary. This is what's commonly referred to as a Allen instruction or a dynamite instruction. It's essentially telling the jurors, we hear what you're saying, give it a little more time. Try a little bit more. If you come back again and say you're completely deadlocked, then we'll go ahead and start talking about what to do next. Which is a strange thing when you think about it. Usually you see that in a case where in a lengthy case like this, they come back within a matter of hours. Here, they've actually put in some significant work. But what's interesting in this case in particular is for them to say that they're hung also means that they have not, this case included lesser included charges. So that means to me that they have not acquitted of the more strong charge, the second degree murder charge, because to move on to these other charges, they have to have first acquitted on the greater charges. So that means that they are likely hung on that issue. Otherwise, I think we would have heard we have verdicts on some, but are deadlocked on others, something along those lines. As of this recording, and it sounds like this may even push them into the weekend. I wouldn't be surprised if the judge says, listen, think about it over the weekend, sleep on it, come back on Monday and start fresh. But right now it sounds like they are deadlocked, or at least indicating that they are, which, again, it was a complex case. It was a case that was presented with very persuasive arguments on both sides. So we'll see if this case is actually going to reach its conclusion, or if we're going to be dealing with Karen Reed the redo at some point in the future. We will keep you updated. Let's move to Orange County, California, where stepping further into the world of the bizarre, an Orange County judge was ordered to stand trial for the fatal shooting of his wife following a decision by a Los Angeles Superior Court judge. Jeffrey Ferguson, a member of the bench in Orange County, is accused of the murder of his wife, Cheryl, with the proceedings moved to neighboring LA County to mitigate any possible conflicts of interest due to Ferguson's ties to the judicial system in Orange County. Prosecutors say Ferguson was in a drunken argument with his wife about finances, which began publicly in a restaurant before spilling over into the couple's home. Ferguson allegedly pointed a finger gun at Cheryl in the restaurant in front of the couple's adult son. And later in the home, Cheryl allegedly said something to the effect of, "Why don't you point a real gun at me?" That's when Ferguson drew his .40 caliber Glock from his ankle holster and shot Cheryl in the abdomen, according to police. The couple's adult son says he then wrestled the gun away from Ferguson before calling 911. Ferguson's defense sought to dismiss the murder charge, alleging that even the adult son, the sole witness to the crime, believed it was ultimately an accident. The argument was ineffective with Judge Eleanor Hunter, who believed the evidence was sufficient to try Ferguson for murder. Ahead of trial, Ferguson will remain free on $1 million bond and be subject to GPS monitoring and alcohol restrictions. All right. In the Reed case, prosecutors spent a lot of time and energy talking about Reed's statements after the discovery of the body. We just talked about this. I hit him, I hit him, I hit him. It's a good way to segue into this case, where in this case, the Ferguson allegedly said to responding officers that I deserve it. I got everything I got coming. And I think this demonstrates just how powerful the statements out of a defendant's mouth can be directly after or near in time to the crime. In other words, pretty much anything said before attorneys get involved. It's powerful stuff. Again, in Karen Reed, not to revisit that case too much, but she's saying I hit him, allegedly, before attorneys are ever involved. That's powerful. I think that really goes towards the true state of mind of the declarant and, arguably consciousness of guilt. Same thing, if not more so, in this case, with him, Ferguson, allegedly saying the words, I deserve it, I got everything I got coming. I mean, short of saying, I killed her, please lock me up, that is very powerful consciousness of guilt, admissions type statements. No attorneys are present. He hasn't asked for an attorney. Miranda issues are likely not relevant because this is a voluntary statement. I think that's going to be very powerful evidence against him and likely used if this ever heads to trial as a cornerstone of the prosecution's case. Another question this case, though, obviously brings up is the idea of his position as a judge. What role will that play, and what role, if any, should that play in the proceedings? Now, I know a lot of you respond to that question and immediately say it should play no role whatsoever. Everybody should be treated the same under the law. Justice is blind. I agree with you 100%. As far as it goes to whether or not this man should be charged with murder, whether or not a prosecution for murder should be sought, absolutely 100%. Nobody should be treated any differently. But when it comes to plea negotiations or sentencing considerations, I think, and this applies again to anyone, whether they be a judge or a janitor, everyone should have the opportunity to present who they are as a person, and whether or not that should affect any kind of plea negotiation or sentencing considerations. In this case, you've got a man who never committed a crime in his life that we know of, and I certainly suspect that's true given that he's a judge. He's presided over cases like this, dealt with this world, committed his time to public service for so long. I don't know him as a person. He could be an awful person. But I'm just saying, based on what I do know, it sounds like someone who, yes, justice is blind, but in the administration of it, with the plea negotiations and what a judge should take into consideration as far as sentencing, I think that should be considered and will likely go a long way in this case. Will that mean he won't spend a very long time, if not the better part of his life, in prison? Probably no. That brings us to the question of, is a plea likely in this case? It's really going to come down to what that plea is. If that plea, I think, gives him any opportunity to spend any time outside of prison after that, he may take it because you make a statement like, I deserve everything I got coming, that's hard for your attorneys to get around. And so he may want to take advantage of that rather than going through a trial and dealing with sentencing after that. And so if they're willing to, meaning the prosecution, offer him something that it gives him an opportunity to see some daylight at the end of his life, he may take it. We will keep you updated. We will follow this case. I find it fascinating for many different reasons. Finally, let's move on to Miami, Florida, where evidence in the prosecution of an OnlyFans model will be excluded after a judge ruled that prosecutors violated attorney-client privilege by accessing private family conversations with their representation. Courtney Clenny is facing a second-degree murder charge for the death of her boyfriend, Christian Abumsele, in a prosecution that also has seen her parents charged for allegedly destroying evidence. The evidence was related to a laptop owned by the victim, which the family gained access to after Abumsele's death. Prosecutors learned of the family's access to the laptop after uncovering messages exchanged, and this is important, between the Clennys and their representation. This was ruled to be a prosecutorial violation, and evidence of the messages concerning the laptop will not be allowed. However, it is unclear if prosecutors will be forced to drop the charges related to the destruction of evidence. While the impact of this development will have on the eventual murder trial is not yet known, defense attorneys for Clenny have asked for the prosecutors in the case to recuse themselves from the proceedings. All right, first, is this a clear violation of attorney-client privilege? I think absolutely. I think the judge, in making this ruling, got it right. These are communications that were allegedly stumbled upon by the prosecution that are taking place between attorneys for Clenny, attorneys for her parents, between Clenny perhaps, any of that, all of that. You need to create a barrier around, and you should err on the side of caution in giving them more protection than less. The attorney-client privilege, I think, is one of the most important privileges that makes our entire system work, because if you don't have a place for a criminal defendant to be able to freely share everything they need to share, it should be with their attorney. And if you start to violate that, infringe upon that, close in the boundaries of that type of protection, we're talking about real problems on the whole in our criminal justice system. So I think there was a violation here. And I think part of that violation just came from sloppiness and maybe laziness on the part of the prosecution than real bad intent. In other words, if they're going to be searching through things where they're even likely to find communications like this, they need to have a clean and dirty team, meaning you need to set aside prosecutors their job is going to be to go through that. And if they do find information they shouldn't stumble upon, they immediately stop their search, and they're able to separate off the information that the prosecution team is allowed to have and the information that they're not allowed to have, and then make sure that those prosecutors don't communicate with each other. This happens quite a bit. You have that dirty team who's seen the things they shouldn't see, but they're not going to be part of the clean prosecution team or deal with them or share that information. They didn't do that here, and that ran them straight into problems, which are big problems because they have to do with the charges about tampering or destroying evidence. And I think that those charges likely will fall because of this exclusion of evidence. But I think the bigger question is, they should be dropped anyways. What are you doing here, guys? Who are you prosecuting? You've got a murder case. Go after the murder case. Prove your case. Quit going on these side quests of trying to prosecute the woman's parents for just trying to help their daughter out. I mean, I don't even see a sympathy angle here. If you're saying that the parents were deliberately going in and destroying massive amounts of information and evidence, okay, fine, maybe I can see it. But you're saying that they tried to get into a computer that was allegedly a shared computer, and perhaps they stumbled upon things that you would have liked to have controlled the discovery of that yourselves. Quit it. Quit with the side quests. Quit with the prosecution of the parents. put that aside and concentrate on the task at hand and the job that you have in front of you. Because, by the way, it's very important to everybody involved. You've got a dead man and you've got a woman on trial for her life. Let's handle this with some decorum and seriousness and quit overreaching and try your case. And how could this affect the forthcoming murder trial? I don't know. I don't think it's much. I think it's kind of a side issue to what she actually did. But I think more importantly, what it's starting to show, and apparently this is not the first time this state's attorney's office has come under fire for misconduct, they're walking on what I would call thin ice with the judge at this point. And these requests to have them recused, I don't think they're going to be granted at this point, but I guarantee you this is probably the last straw. And if you see any of this continued silliness on the part of the prosecution, you very well could see a judge saying, you know what, state's attorney's office, sorry, but you've had your fun, game over. I'm assigning this to the attorney general's office or whoever else would need to take over. And then you're talking about much bigger problems than, the parents meddling in the case. Prosecutors have a bigger responsibility beyond just trying to win. They have to do things the right way. They have to represent the people. They have to represent something larger than themselves, which is essentially standing for justice. Your job is not just to win. I was a prosecutor for 10 years. Many times I would go to my supervisors and say, either we cannot win this case and we shouldn't waste everyone's time, or we're doing the wrong thing here, or we've overcharged this, or what have you. And empowering prosecutors to do the right thing should be part of the job so that they can do that, because they are many times that vanguard. They are many times the person who has the most ability to stand there and say, let's make sure we do the right thing here, not just win. That's my little soapbox for the week. That is our show for the week. I've enjoyed having this conversation with you. I wanted to really give a special thanks to all of our listeners and viewers for sticking with us and bringing us into your lives each and every week. I'm your host, Josh Ritter. You can find me on Instagram and Twitter at Joshua Ritter ESQ. And if you want to hear my thoughts and coverage and hear me talk about even more true crime cases, you can check me out on my brand new YouTube channel, Courtroom Confidential. And you can, of course, find all of our Sidebar episodes wherever you get your podcasts. And we want to hear from you. If you've got questions or comments you'd like us to address, tweet us your questions with the hashtag TCN Sidebar. And thank you again for joining us at the True Crime News Sidebar.